All right.
On the case, we're still waiting for a PSI interview to occur. In the meantime, Ms. Bash has taken additional classes, and this gives her additional time to take a few more classes, and she's currently enrolled. There's a verification letter that she's doing more substance abuse classes.
All right.
And
So on this case, does anybody want to see if the court can get an expedited PSI?
That would be great, Judge.
All right. So just give me a moment and I'm going to see if I can get this. It would have to be at the beginning of December.
That would hopefully mean that they're back here before Christmas.
Yes.
That's the goal.
All right. So let me make a phone call and then we'll see if we can get that done. Anybody have a copy of the motion to revoke?
I do, Judge, but it's full of notes.
Okay, let me see. I can pull it up in the email. Ms. Abrams sent it. It's just, sometimes it's easier seeing the paper.
I wouldn't want to expose this court to the prejudicial notes that I have here.
Oh, let's not do that. And Mr. DeLeon, I'll be reviewing the motion to revoke, not to decide whether or not things are true, but just to make a decision on if I were to grant your motion for a bond, that the conditions I set are appropriate. Okay.
We can do that.
Ms. Abrams,
Yes.
do you have a copy of the motion to revoke on Mr. DeLeon? I don't see it.
Yeah, clause number, I don't think it's listed in MTR.
All right, it's DC 20.
I'm printing it for you, Rick.
Oh, thank you.
You're welcome. I already had it pulled up.
Rick is anticipating. I like it.
Teamwork, good.
Yeah, it makes the dream work. All right, while they're printing it out, the court is calling 2024 CR 3774 State versus Luis DeLeon. Could I have parties announced for the record for the state? Defense? For the defense?
Patrick Ballantyne for Mr. DeLeon.
And are you Mr. DeLeon?
This one.
State, any objections to the defense appearing by Zoom?
Judge.
And Mr. DeLeon, do you have any objection to your counsel appearing by Zoom?
No.
All right, you are here. Oh, thank you.
Well,
You're here requesting that a bond be set. Is that correct, defense?
That is correct, Your Honor.
All right, and it's the court's understanding that you all have reached an agreement?
We
as to, Judge, but perhaps not two conditions.
All right. Any witnesses with regards to conditions for the court to set?
Yes, Your Honor, we would call Mr. DeLeon.
All right, Mr. DeLeon, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Louis DeLeon.
All right, defense, you may proceed.
So, Mr. DeLeon, the court is presently considering whether to grant you a bond on this motion to revoke, what that bond should be set at, but she also needs to know if there's any special conditions that need to be imposed as a condition of your bond. I'm going to ask you about a couple things in particular. First, I want to start with any history of mental illness that you might have. Do you have, or have you had in the past, a diagnosis for any mental illness or disease?
No, sir.
Are you receiving or have you received in the past any treatment or therapy for mental health issues?
No, sir.
Okay, I want to ask you also about substance and alcohol issues that you might have. Have you ever received any treatment or counseling, whether court-ordered or voluntary, for any substance abuse or alcohol abuse issues?
No, sir.
Okay. You're under oath, and can you affirm to this court that you do not have an issue with substance or alcohol abuse?
No issue, sir.
Are there any
Alright.
other I'm sorry. Are there any other special conditions that you're aware of that this court might need to impose as a condition of your bond?
No, sir.
Okay, thank you, Judge. I'll pass the witness.
Any questions?
And if I may just talk about procedurally, the new case judge, not the substance of the new case.
Yes, can you tell me, the name of the complainant?
And the new case judge,
Yes.
it is Ms. Natalia Aguilar.
All right.
Mr. DeLeon, did you get picked up in a bond set August of 25 this year from the new assault case?
Yeah. Yes,
You get arrested?
Yes,
In August?
yes,
They set a bond.
yes.
And then was that bond forfeited?
I'm not sure, honestly. I believe last I heard it was like 4,000
Did you get rearrested in that case?
on it's in August.
Yes.
I turned myself in for the MTR.
You turned yourself in for the MTR.
Yes.
Were you aware that there was a failure to appear in September?
No, when I talked to my probation officer, it was August 27th, I believe, and she said that she was gonna, I guess, I don't know what it's called, but essentially she was gonna, so that there was no violation, she was gonna essentially, I don't know, waive it or something like that. And then once I turned myself in, everything would sort itself out.
Or they set that bond again, September the 4th?
I'm not sure, sir.
No additional questions, Judge.
All right. So do you all anticipate this being a contested hearing?
Unsure.
Well, Your Honor, I guess you've looked at the MTR at this point. There's a new number one that would be contested. The number two allegation, I need to confer with my client, but I don't know that that would be as contestable. So I am.
All right.
That
Ms.
that's the best
Ferguson?
I can tell the court today.
All right, this is going to be set for a contested hearing. Ms. Abrams, are you able to have, if there's a need for an officer, are you able to have that officer here? We can put it on December, either December 9th or December 16th. All
Judge,
right,
oh,
yes.
okay. Is December 11th available? Because I have some other cases in your court that day.
All right, let me see. Ms. Abrams, is December 11th?
Yes, Judge.
All right, December 11th. And Yaya, could you do a reset form for contested hearing? So your contested hearing is going to be December 11th. You need to be here. If you're not released, you will be brought over from the jail. So the court is going to follow your agreement. Bond is going to be set at $50,000. There's to be no contact with the complainant and the alleged new number one. And state, do you believe you'll be able to contact the complainant to let them know he's received bond today?
Yes, Judge. Cool.
All right,
Is this the complainant on the new number one, Judge, or the complainant on the underlying offense?
both.
We'll let them both know. And for the court, we were discussing several times.
Oh, the defense wrote on here that, that was the original bond amount, correct?
The original was 50,000. That's correct.
That's what was written on. I thought that was the agreement. So do y'all have an agreement or no?
I think we did, Judge, accept that.
All right, then the court will follow your agreement. The court will set your bond at $75,000. As I said before, there's to be no contact with the complainant and the allegation of the new number one. And of course, there's continued no contact with the complainant for the instant case. Do you understand? All right. So parties, if this is going to be contested, you all need to be prepared for a contested hearing on December 11th.
Yes, ma'am. Judge, the state further was asked for GPS, but that part was not.
All right. Mr. Valentine, the state is asking for GPS. You're opposed?
We oppose that, Your Honor. We don't believe it's a necessary condition in this case.
All right. And state, what is the reason for your request of GPS?
The underlying offense, Judge, for which he was placed on probation earlier this year, fled to indecent assault, and was fled down. So he'd only been on on supervision for 6 months, 5 months, 6 months before he's rearrested for this new offense, because there's another violent offense on the state. He is a danger to
All right, and defense?
I'm having a little trouble hearing Mr. Morris, but I believe the concerns he's expressed would not justify anything like full house arrest. I don't think that GPS is necessary. This is not an instance of some sort of assault or improper contact with the victim in the case before the court. So, Your Honor, we would either ask that GPS not be imposed and that issue be left to the misdemeanor court's discretion handling the new number one, or if the court does see fit to impose GPS, it be tracking only with to monitor any contact that he might have with the two no contact subjects in the case.
All right, this is what the court will do. There's a $75,000 bond, which is agreed to by both parties. There's to be no contact with the complainant in the instant case or in the allegation of the new number one. There's to be partial GPS, waive fees, and that is for attorney consultations. Is there anything else?
I think from the state judge.
So,
Judge, may I ask that that partial be extended to any employment provided proof of employment is provided to the tracking provider? Or
once there is employment that has been obtained, then the court will consider that at that time.
Thank you, Judge.
All right. So what that means is you're allowed to go speak with your attorneys. That is it. So if you drive to your attorney's office and you see an HEB and you're like, I should stop at the HEB. You're not allowed to do that. You must leave from wherever you're stationed with your GPS. If it's at your home and you have an appointment with your attorneys, pretrial services is going to want to know of that appointment. And then you are to leave there without making stops to meet with your attorneys. Do you understand? Is there anything that you do not understand about the court's orders? All right, so you'll be back on December 11th. That will be for a contested hearing. Both parties will be prepared to proceed at that day. All right, is there anything else from the state or the defense?
I think from the state. Yeah.
Nothing from the defense. Thank you, Judge.
All right, thank you. All right, you're excused. All right, is this a motion to revoke?
It is, and we're ready.
All right, the court is calling Isaiah Johnson or Asai Johnson. Could our parties announce for the record? Could I have a file stamp for a motion to revoke, please?
Ready to go forward.
Okay.
And Mr. Porter?
You're not.
Oh, it's not.
Okay, then we have to set it for contested.
All right, this is going to be contested.
It is. I'm ready for my contestant right now.
Okay. All right, so we're setting this for a contested hearing. All right, Mr. Johnson, your contested hearing will be set in December. All right. Is there going to be any objections to witnesses appearing by Zoom?
Yes.
All right. All right. If you all confer on well, let's do this. On this case, Ms. Ferguson, if you recall it for the first week in December, and at that time states you'll need to be able to tell the court when you'll be ready for a contested hearing and making arrangements for the person in Florida to be here.
Yes.
All right, we'll see you back on December 4th. All right, thank you.
Thank you, Judge. Probation is recommending Saturday.
All right, and who's your client? What's your client's name?
Abelino Lopez.
Could I have the file on Avelina Lopez, please?
I mean safety, not Saturday, safety. He's already done a paperwork.
Okay, 14.
Yes.
There's
No.
no files.
All right, all right, thank you. All right, Ms. Abrams, on this case, is there a top recommendation?
Judge, so for him, the top recommendation is for him to go to safety. The original conditions indicate for him to go to safety if not accepted into felony drug court.
Mhm.
As we are aware, felony drug court is not accepting any new clients at this time. So I did get the safety documents, everything signed this morning.
All right, so you will be going to safety. All right, do you have any questions about anything? Please take advantage of that program and internalize it. And when you're released from safety, make sure you follow through because a lot of people tend to drop off and not go to aftercare, but you'll need to do that. You understand? And if there's anything that you need and you feel as though probation is not addressing it, once you're released, you can come back to the court. You understand? Thank you. And there's a restitution issue?
Yes, Judge, you said for restitution.
Yes. All right, so what we can do, Mr. Porter, after he's completed safety, if there's no objection, we can address the restitution issues.
There is an objection because we're set for restitution hearing today. You don't have any witnesses to go forward, then there should be no restitution. But if that's what the court wants to do, I
Yeah.
understand.
All right, and then state, of course, if you have the items before he's released from safety, and if the state and the defense, if you all can reach an agreement, then we can take care of that and have your client by Zoom.
Okay, thank you.
All right, Ms. Ferguson, if you'll put this, we're just going to put it in February because everyone should have some information by that point. So we'll put it in late February for restitution hearing.
Thank you.
All right, where are we on discovery?
Judge, we should have discovery. There's a misdemeanor out of the same incident. I've gotten discovery through that. I know that I've gotten an offer from the state. We've discussed the case. I'm sorry, I have not gotten an offer because we've discussed the case. The state needs to look at the video before they can make an offer. So we're asking for some time to get that done.
All right, Ms. Ferguson, if you'll set this in the second week of December and state at that time you need to be prepared to tender an offer.
Yes,
Thank you, Your Honor.
Yes. All right, once you sign the reset form, you're excused. Hello, I'm doing great. How are you doing? All right, today is plea deadline date. Have you all reached an agreement or is this going to be a jury trial?
So here's the deal, Judge. There were some CPS records that I just received the disc today. There was also an issue with some body cam that they say has been uploaded to e-discovery. I didn't get them when I downloaded everything, but they say they're uploaded, so they have made an offer. We're not willing to accept that right now. But if we could just reset for the big bargain deadline, see what happens with that new discovery.
All right, this will be your final plea deadline date. Ms. Ferguson, set this for the last week in December, please, that we're here. All right, that will be your final plea deadline date. Counsel, you'll need to provide them with a thumb drive, maybe.
Oh, no, I've got the, for the body cam.
Yes.
Yes, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
All right, today is plea deadline date.
Yes, Judge, we have a plea date on a misdemeanor that will dispose of this case of January 7th in order for him to finish.
Okay, why was that like January 7th? Because we were here in October, and then there was a plea deadline date for November 3rd. Then there was the misdemeanor case that you all were supposed to work out. And then today is the day for.
I understand, Judge. We've worked out the misdemeanor case. There's some classes that are as a part of that deal that I was unaware of when I talked to you.
Mhm.
I understand that we need to set it for trial. And I'm just asking, my request would be we set it on the day that we're supposed to plea, because I anticipate it being resolved, but we're at the
When is
pleasure of the
that?
court, January 7th.
All right, Norma, recall this for January 8th. And that's going to be, well, just one moment, not January 8th, Ms. Ferguson. Do it for January 12th, and that's your jury trial date and plea deadline date. If things are taken care of before then come back.
We'll come back and hopefully we'll be here on the 7th to let you know.
All right, thank you.
May we be excused once we get that?
Yes.
Thank you.
Have you conferred with the state?
I have, Judge. It's really just a clarification of a previous order you already entered, Judge.
Good afternoon, Your Honor.
Good afternoon. So he's asking for contact with his minor children and the motion. Is there going to be any objection?
Did you previously granted that? The problem is in the order you gave him permission to have supervised contact with his children, which we're not objecting to that.
Mhm.
But you also ordered that he cannot have any overnight stays with children. So GPS is interpreting that to mean even if he's supervised, the kids can't sleep in the house with him. So him and the family are having to sleep in separate quarters.
All right. It's going to have to be supervised. All right, is there anything else?
That's all we have on for the judge.
All right, thank you. All right, you too. And if you'll bring up your other client. All right, there's a motion to modify bond conditions. Is there an agreement or no? Okay, all right. Court is calling 2023 CR 2677 State versus David Duenas. Could I have parties announced?
Raymond Martinez, Mr. Duenas.
And are you Mr. Duenas? All right, defense has filed a motion to modify bond restrictions off record. State is stated they're opposed to tracking only. All right. And you're stating that Judge Nahara did order partial GPS for employment or no?
Yes, for employment.
So counsel, what is the issue with partial for employment?
Judge, problem is that Mr. Duenas sells cars, and as you know, car salesmen are constantly on the go, test driving, moving cars, etc. And so with partial, he's allowed to go to the dealership, but he can't leave and actually do his job. So, and in the past, when he's been on GPS, he's been allowed to do tracking for the same reason. He's been in the car business for a long time. The second issue, Judge, is he needs to travel outside of Fair County, sometimes to deliver cars to other dealerships in other cities and or bring them back. And so we're asking for a travel permit within the state of Texas.
All right, any further argument, counsel?
Judge, I mean, the underlying MTR, Judge, that was a trial case before a jury, and that's already been resolved. On the MTR, we're set for contested in December. He's gonna have a whole month out of work if he doesn't get these modifications.
Okay, all right. The motion to alternate main conditions is denied. Is there anything else? All right, thank you. All right, so has the sealed family violence case been taken care of?
It has not, Judge, and Ms. Jones was looking, yeah.
Ashley transferred the state.
All right, so when are you gonna have information?
Your Honor, I put in a request for several.
All right, counsel, will you be here the second week of December?
I will, Judge.
All right, Ms. Ferguson, set this for the second week of December. And that will be for discovery. And if you don't have the information, you all will need to present on the record the reasons why that information is not available for defense, who has it, and they'll need to come down to explain why the defense doesn't have it. What date? All right, we'll be back on December 11th.
Thank you.
Thank
Judge.
you. Why were you late for court?
I went to the one downstairs at Essex. When I grew up.
All right, so here's the thing. What court did you have downstairs? Which court?
Forgot that I got a new judge. So
Okay,
I went to the wrong one.
all right, so now you know where it is. You should have already known where it was because you've been here before. So do not make that mistake again, all right? All right. State, were you able to tender an offer in this case? It's Israel Gonzalez. And I believe this is going to be family violence as well.
He just got indicted on another case, Your Honor, which has just been handed the indictment.
Okay. And is that through family violence?
Yes. Well,
Family violence.
Yeah.
You have Israel Gonzalez. Do you, with regards to that case, are there CPS records? And while they're looking for that, do y'all have all of the paperwork on Henry?
I turned in most of the plea bargain, everything good. I think we're waiting on the app and the cert of appeal.
Is that the only thing that's missing, the cert of appeal?
Yes, and the application for deferred.
All right, if there's an issue with that coming through, we can just put it on the record that that's what she's applying for.
Okay.
And we'll put unable to sign due to whatever is happening with the emails. Is that the only thing that's pending? Yeah, is that the only thing that's pending?
I haven't received any of the paperwork.
So you don't have the court admonishments?
I don't have the admonishments or anything else.
No, it's all signed.
I signed it.
I know, I got the completed email.
On your case, I anticipate we're gonna have to do that at 1:30.
Okay.
They will have your client sworn in and we'll be ready to proceed and you can appear by Zoom.
Thank you, Judge.
You're welcome.
Appreciate it. I'll let her know.
I'm just waiting for information.
Okay, Judge. I have three clients.
All right.
Then I have 8
Oh,
in
you're back
medical side waiting for me.
Well, he has another case.
Yes.
That's another second-degree felony with family violence. Yes. So this is what we're gonna do. Norma, recall this for the last week in December. State at that time, you need to be prepared to make a global offer.
December what?
And
What?
state on that case, that family violence, if there's CPS records, you need to obtain those. If there are phone records, mental health records, school records, you need to obtain those.
Yes, Your Honor, I apologize, it's
Um,
pulling up, I do believe it's not.
And Your Honor,
It's not
I
indicted
also
yet,
have,
so it's just paper.
Yes.
also have the issue, my client's been on GPS monitor since April. Of the alleged, the second crime, offense that he's been indicted for. And I filed the motion to remove the GPS, but it was in the wrong court because it was not indicted yet, so I would ask court to take up that, but I guess I would have to file the hearing, the motion, so we can set the hearing so you can hear it.
Yeah, and what I can tell you, if he has all of these cases that are on different dates, there needs to be a good reason for GPS to be removed, because let me just tell you, I don't take any of these offenses as you're guilty beyond a reasonable doubt, because I have not had anything presented to me. But what I can tell you, if you have a felony bond and you are alleged to have committed a new offense, then maybe GPS is where you need to be. You understand? All right. Do you have any questions about anything?
Oh, yeah.
All right. Once you sign the reset form, you are excused. All right. Thank you.
You're sign right there. Sign right there.
Who's next?
Page 5, third one down, and Enrique Jacobo. Let's let the interpreter.
Hold on.
All right. Is the interpreter here?
Yes.
Do I have a seat, sir?
Not yet, Judge. We've actually filed a motion to suppress on the matter. I think it would be a dispositive matter or motion, excuse me. Pending that, I think there could be a plea after that, but
All right. Is the motion dispositive?
I believe so, Judge. Yes.
All right. All right, state.
Yes.
They're saying that they want a motion to suppress and it will be dispositive. All right. Are you able to do this before the new year? You mean December? All right, Ms. Ferguson, if you can put this for a motion to suppress second week in December, please. Are you all okay with having this on the 12th? That's a Friday. Would that be easier than the 11th? All right, Norma, put it on December 12th, please. All right, thank you. And I did that because I think it will be easier because we have an interpreter and there are a lot of moving parts.
Sure.
All right, thank you.
Thank you, Your Honor.
And if you could sign an acknowledgement of discovery before you leave.
Absolutely.
Hi, how's it going?
Good, how are you?
All right, are you all ready to proceed on the MTR?
We are, Your Honor.
Court is calling 2024 CR 012263, State versus Miguel Contreras. Can I have parties announced for the record for the state?
And Lauren left in for Mr. Contreras.
All right, and are you Miguel Contreras? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Miguel Contreras Jr. who's placed on deferred adjudication in 2024 CR 012263 for the offense of evading arrest detention with a previous conviction on January 23rd, 2025 for a period of 4 years? Is that you? All right, state. How do you plead to that? True or not true? State?
Please abandon their maintenance, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
There is
Yes, Judge. It is for
he's, not to interrupt, but he's already completed his mental health, so the agreement was for him to do the outpatient dual diagnosis intensive program, is that correct?
Caseload and for him to complete the dual diagnosis outpatient program.
Thank you.
All right, thank
That's
you.
what I tried.
All right, you want to raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. All right. Mr. DeLeon, do you need a cough drop? Okay. All right. So what has been going on with you?
I was staying at my brother's, but it didn't work out there. Them getting like a power of attorney over me or whatever for helping me with this.
So this is, I'm going to give you a choice. I don't know if you'll be successful in this probation or not. My hands are sort of tied with the different programs that I can have available to you because there's a lack of funding. There's a lack of placement. Now, I can follow the agreement that has been reached, or I will sentence you to 8 months in the state jail facility. So do you want me to follow the agreement?
Yes, please.
Okay. So the court will deny the motion, alternate amend conditions to include MHI plus outpatient treatment with dual diagnosis. And Ms. Abrams, because there may be issues with him, can you make sure that they do the field visits? And so there'll be field visits 1 time per month until further notice. And we're doing the field visits to make sure that you stay in compliance, okay? I want you to be successful at this.
And I don't know if the court could order, but I did tell him to ask for employment resource or help with that, and as well as housing assistance.
All right, so employment resources and any housing resources, Build Back Brighter, something of that nature, they can help with housing as well. They're a nonprofit, but they may be able to help you.
I'll Google it and maybe write the information down.
All right, thank you.
Okay, thank you, Judge. May I be excused?
Yes. All right, what is happening with your case, counsel?
Judge, we had requested some discovery. We did receive some partial discovery from the lab, but we're still in need of the rest of it. I've spoken with the state on that. And I believe we should hopefully work towards a resolution soon, but I don't know how soon it's gonna be for us to get that.
And what discovery is outstanding?
It is gonna be like similar to blood discovery. The process in which the lab evaluates any PG2. There's gonna be a process, there's gonna be a number of things I've requested from them. And I've received that. I've only received a chain of custody law.
All right, Ms. Ferguson, let's set this for the last week in December. Let's see where we are in discovery. All
Thank you,
right.
Judge.
All right, once you sign the reset form, you excuse. And Mr. Ibarra,
Yes, ma'am.
what time is court? Why were you not here?
I was in there, huh?
All right, so here's the thing. How old are you? You're 18. Court starts at 9. You need to make sure you're here at 9. You understand? All right, thank you. All right, what is happening with Mertens?
Yes, Judge, we're here for discovery. We are in need of about a terabyte worth of discovery. I need to provide a drive to them. I don't have one available today, but I can get one to them. But there's about a terabyte worth of videos that I need.
All right, and your other client is coming back on the
15.
All right. Norma, recall this for the 15th to make sure that they have discovery.